Imagine you fought a legal battle for 20 years and finally won. But then life got busy, and you did not file execution proceedings. After 12 years, the losing party returns and says, "Your decree has expired. You have lost your rights. Is your victory really gone?" Today, we are discussing a major relief given by the Supreme Court of India in April 2026. We will analyze Civil Appeal number 4402 of 2026, Hari Ram vs. State of Rajasthan, which clarifies the law on the 12-year limitation rule. I am Advocate Mukund Mahajan, and you are watching Legal Information Law Insights. Our mission is to empower you with the truth of law. Now, let us understand the legal position. What does the law say? Article 136. First, let us understand Article 136 of the Limitation Act, 1963. Article 136 provides a limitation period of 12 years for execution of any decree, except a decree granting mandatory injunction. Execution means requesting the court to implement the decree through legal process, such as delivery of possession, recovery of money, or enforcement of rights. However, if the decree is for mandatory injunction, such as directing someone to remove a construction or perform a specific act, the limitation period is 3 years. Because of these limitation periods, many parties argue that once 12 years pass, the decree becomes useless. But the Supreme Court has clarified an important distinction. Case profile: Hari Ram vs. State of Rajasthan, 2026. Here are the details of the landmark judgment. Case name: Hari Ram vs. State of Rajasthan and others. Case number: Civil Appeal number 4402 of 2026. Bench: Justice Sanjay Kumar and Justice K. Vinod Chandran. Judgment date: 10th April 2026. In this case, a very old decree passed decades earlier was questioned. The opposing party argued that since no execution petition was filed within 12 years, the decree holder had lost all rights. The Supreme Court rejected this argument. The house and key analogy. To understand the judgment easily, consider this analogy. Your house represents your legal right. Your key represents your legal remedy, meaning the right to seek execution through court. The Supreme Court explained that after 12 years, you may lose the key, meaning the remedy of execution may become time-barred. But your house, that is your underlying legal right, does not automatically disappear, especially if you are already in possession. Key legal principles laid down by Supreme Court. 1. Remedy and right are different. Even if the limitation period for filing execution expires, the underlying legal right created by a declaratory decree does not automatically vanish. 2. Possession plays a crucial role. If the decree holder is already in physical possession of the property, execution may not be required where the decree holder is already enjoying possession. The decree may continue to operate as evidence of title, particularly where possession remains with the decree holder. Friends, you are watching this video prepared by Advocate Mukund Mahajan. If you find our content valuable, please consider becoming a channel member via the GPay QR code on your screen for 59 rupees or 119 rupees. Your support helps us continue providing high-quality legal education. Now, let's dive further into more details. 3. Decree can be used as a shield. The Supreme Court clarified that an old decree can still be used as a defense if the opposing party later challenges ownership. Thus, even after many years, the decree holder can rely on the decree to protect rights. Important legal clarification. This judgment mainly applies to declaratory decrees, especially where the decree holder is already in possession. It does not mean that all decrees can be ignored after 12 years. If a decree requires active enforcement, such as delivery of possession, recovery of money, removal of encroachment, then execution should still be filed within limitation to avoid complications. Important caution: adverse possession. There is one important warning. Even if the decree does not expire, your rights may still be at risk if you are not in possession. If the opposite party remains in continuous possession for more than 12 years and claims adverse possession, they may attempt to extinguish your title. The law protects those who have rights, but it does not protect those who sleep over their rights while someone else occupies the property. Practical action steps for property owners. What should you do? First, check your possession. Physical possession strengthens your legal position. Second, if you have a declaratory decree, you may rely on it to seek mutation in revenue records, subject to satisfaction of the revenue authorities. Third, if you are not in possession, do not wait. File execution proceedings within 12 years to avoid legal complications. Conclusion. This 2026 Supreme Court ruling ensures that justice is not defeated merely by technical limitation periods. It clarifies that non-execution of a declaratory decree does not automatically destroy the legal right, especially when the decree holder remains in possession. However, timely legal action is always advisable. Thank you for watching this video. If you found this information useful, please like, subscribe, and share your views in the comments. Don't forget to press the bell icon for more legal information. I will meet you in the next video soon. Jai Hind. Jai Bharat.